everyone, and welcome to the autumn series of the IQ Legal Training and Stewart Title webinars. In our first session today, we'll be looking at the new planning reform and key issues for residential conveyancers. My name is Stephen Smith, and I'm delighted to be joined once again by Ian Quayle and my colleague Robert Kelly. Good morning to you both. Good morning, Ian.
Morning.
How are you, Ian? How's your summer? Just very quickly.
Excellent summer, Stephen. Yeah, very busy. Taking up sea kayaking. How about that for something different?
Fantastic. Yeah, excellent.
Keeps me out of the way of COVID and keeps me out of mischief. But yeah, busy and good. But I'm delighted to be back. The Three Musketeers are back on the road again, which is nice to hear, isn't it? Nice to be with you again.
Absolutely, yeah. It's great to be back, and it's great to see so many familiar faces and some new faces logging in today. So welcome to everyone. Before we get started, I just want to go over a few items, as I always do, just to allow you to participate in today's webinar. So by default, you are logged in via your audio speakers on your computer. You can dial in through the telephone, which is toll-free. You would just click on the telephone option and dial in there and use the PIN instructions. It's fairly straightforward, but it is free. So and the sound is very clear on the telephone as well. You'll have the opportunity to submit questions throughout today on the text panel that you have there. If you do have any questions, there will be a designated Q&A at the end of today's session, so we'll try and catch most of them then. You can also raise your hand using the raise hand feature on your control panel if you wish to ask any questions directly to myself, Ian, or Robert, or if you have any technical issues as well that you want to discuss, maybe you're having problems with the sound, then please get in touch. We have included the notes in today's session in the handouts. So if you can't access those or you're having trouble accessing those, I can also send you an email so you have the notes to follow along with the session. Just before I pass over to Ian, we just want to run a quick poll, get you involved right at the start of the presentation. So I'll just put that on screen now. The question is, how are you all currently working? So I'll just leave that on screen for 10 or 20 seconds or so. So the options are all in the office, all working from home, allowing staff to choose between the office and home, or setting fixed days for the office. Okay, that's over 60% of you voted there, so I'll close the poll and share that. So there's a real mix there, Ian and Robert. I don't know if you can see that,
yeah,
but pretty split between the four, which I guess it could be to do with the geographical locations of everyone. We're currently still generally working from home, going to the office now and again, but I think the government guidelines recently have maybe halted any progress to go back in a more full-time sense. Anything that you can make of those numbers there, Ian?
No, just interesting, isn't it? I would have thought there'd be more people working from home, but that's been probably because of where I am. Most of my colleagues, etc., are working from home at the moment, so I'm quite surprised at that. Surprised about the number of people that are sort of setting fixed days for office. You know, I would have thought there'd be a bit more flexibility about. But interesting, isn't it? Interesting stats. These polls are very useful just to see what people are doing. And as I say, it's quite enlightening that, and got a bit of a surprise with the how few people are working from home at the moment.
Absolutely, yeah. But I mean, I think good as well to see people are getting back to the office. It's something that, you know, is going to be with us for a long time, it would seem. So we need to find ways to adjust, I guess. Yeah. Anyway, thank you to everyone for answering that poll there. Ian, I will pass over to you for the main part of the presentation.
Thank you. Thank you very much. Well, first of all, good morning, everyone. Thanks for joining us. And thank you to Stewart Title again for sort of sponsoring these events. It's great that they are still supportive of the profession. We're busy, aren't we? Everyone's busy, which is good news. And really what I want to do in this hour is to introduce the new planning regime that this government is hell-bent on putting forward, to look at that, but also look at some practical issues, look at some law that's been introduced with regard to permitted development, and just to sort of refresh some of what I would consider to be best practice with regard to a residential conveyancers interface with planning issues. So lots to talk about, lots of things to do. Anyone has any questions, Stephen is more than capable of dealing with the chat that comes in, and there is an opportunity at the end for questions. And for those of you that manage to stay awake, there is an opportunity on the last slide to contact myself or Stewart Title with any questions that you have as a consequence of what we are saying today. And I have to emphasize, it is really great when people do provide or ask questions either in the format of chat or in the format of emails, etc. It's really nice to engage with people to see, what's causing issues, what's causing problems, because certainly that, you throw up ideas and throw up issues that I haven't considered or didn't appreciate were of significance as far as practice is concerned. So loads of things to talk about. So let's get talking. First of all, in the notes, I talk about some basic issues, and I want to deal with those basic issues if we can. What's the role? What's your role as a residential conveyancer in connection with planning issues? I'm a transactional property lawyer, and therefore, as far as planning is concerned, all I'm required to do is identify the planning status of the target property. Do I have to go a little bit beyond that and assist my client to determine whether or not the target property can be utilized for the client's objective? In other words, if my client intends to undertake some form of development, working from home, as we've just seen, for example, is there an issue with regard to the construction of an office or conversion of an office? Are there these sorts of issues that mean I have to advise the client about their intentions relating to the target property? It doesn't matter what you do, but what I would say is the base level for a residential conveyancer is to identify the current planning status of target property. If we have identified client objective that involves some form of development, then I think we've got a decision to make. Either we're going to assist our client with regard to planning issues relating to that objective, or we're going to draw a line as far as the client is concerned and say, look, no, that's beyond the scope of our retainer. In circumstances where we are going beyond the scope of a transactional retainer and getting involved in planning work, one, do we have the expertise to deal with that? Two, are we going to charge the client for the additional work that's involved? Or three, are we going to push out that side of the work to a planning consultant or a planning lawyer to assist or advise our client? I think the important point is the point that I make on the bottom of this particular slide. Do you understand what your role is? And more importantly, does the client understand what your role is? So we've got to draw a line somewhere and make sure that the client understands or appreciates what we're doing and also what we're not doing. It's funny when I think about that. I was speaking at a conference a couple of years ago now, and a guy from the Law Society was getting some major flack from the speakers about the code of conduct. And what he said was, I want you to remember, is that in the past, he said, with regard to code of conduct, there were rules, there was a line, and everyone knew where the line was. These days, with regard to the current code of conduct, what we've done is created a mist or a fog. And what we've said is somewhere in that mist or fog, there's a line that you can't cross. And therefore, what happens is no one goes anywhere near the mist or the fog. Well, the point here is, again, I think it's important that we draw a line to say to the client, this is what we're doing, this is what we're not doing, and there isn't this mist or fog without any form of line in there. And therefore, if the client is sort of stumbling around thinking that we're giving advice with regard to planning, it's important that we set the record straight right from the beginning and indeed throughout the transaction. Now, I don't mind whether we're going to give advice or we're not going to give advice. What I am very concerned about is that the position is quite clear. So in our engagement letter, in our emails to clients, does the client understand what we're doing and also what we're not going to do with regard to planning issues? The next thing to talk about are sources of information. We all know about sources of information quite clearly. It is important to understand and for a client to appreciate the limits of the resources or the extent of the resources that are available to us with regard to searches, with regard to TA forms, with regard to the extent of the information that we're going to arm our client with as part of the conveyancing process. So as far as local searches are concerned, they will generate some information relating to target property. Important point, if there is any adverse entry, any reference to any issues relevant to planning or indeed otherwise that warrant or require further or additional work to be done, the client needs to know that fact. So we need to advise about adverse entry, need to advise about what work could be done with regard to that adverse entry or with regard to additional work to carry out further investigation with regard to the problem, and then say to the client, do you want us to do that work or not? It isn't enough to say to the client, there's a local search, there are some adverse entries, there's some reference to planning conditions or listed buildings, etc., and not go beyond that. Hey, Mr. Client, the property that you're buying is listed, or there's a building on the site that's listed. This is what we should be doing next in order to protect your position. Same with regard to TA forms, same with regard to pre-exchange inspection by client, or anything revealed by estate agent particulars, or anything revealed by specialist planning searches that we might undertake as a consequence of adverse information that's generated elsewhere. Remember what the Law Society and SRA remind us about, the fact that when we're doing or undertaking searches or undertaking due diligence on behalf of our client, we've always got to bear in mind the big picture. And the big picture is client objective. You know, if we've got search results that are adverse, how does that impact on client objective? What can we do in order to find out whether or not what we've identified or what the search has revealed is going to impact on what our client intends to do? Very important that we appreciate that adverse entries, adverse information warrants further investigation. Clients call, do you want us to do this or not? There will be a cost consequence. And of course, all the time, we've got to bear in mind the position with regards to our lender. We've got to transmit information to clients in a meaningful manner. Clients have to be aware of what can be done next. Clients should be informed about what can be done and the consequence of not doing that. And then what I've done to really upset you this morning is giving you a little bit of case law in the notes. AW Group against Taylor Walton, 2013 decision, commercial property transaction, but it gets the point over, which I want to get over this morning. Here we had a situation where lawyers acting on behalf of a buyer became aware of some planning issues. And all the court said is that they should have reported that to the client, advised the client that it would be appropriate to seek specialist advice, make sure that clients had received sufficient information so that they understood what the problem was, and then after that it was the client's call. So in failing to advise about the problem, in failing to advise that further steps could be taken to ascertain in more detail what the problem was and how the problem could be resolved, the firm was held to be negligent. So this case highlights, one, the need to ascertain client objective, and that's across the board in resi or commercial transactions. Two, if we get adverse search results or we get information relating to planning that potentially could impact on client's objective, we tell the client about that and what else can be done. In addition to that, I think it's important that we explain to the client that there is a cost implication with regard to the work that we are going to do that is over and above what a transactional property lawyer would normally do in this particular case. Interestingly, this was a High Court decision. One of the judge emphasized, one of the points that he made in the case was, in communicating with clients, we've got to be clear that we are communicating effectively. So we've got to make sure that clients understand what we are telling them. Hey, this is what the search reveals. This is how it could impact on your objective. This is what we can do to further investigate that problem or issue for you. So quite a scary case, to be honest with you, but just sort of confirming, I'm sure, what we already know. But I mention it just to sort of reiterate the importance of making sure that if we get adverse entries in, or if we get information relating to planning that's relevant to the client's objective, that information is transmitted to the client. Now let's look at a default position. We don't want to know what the client's objective is. We haven't asked the question. In those circumstances, we must advise the client of the current planning status of the target property, and we must advise the client of our search result of our due diligence process, and of anything else that is generated either by client inspection, survey or valuation, or search results. So enough of that. Let's move on and let's talk about what we have got in connection with the government white paper and the suggested reform of the planning system. The current planning system has been blamed by just about every conceivable party that's involved in the planning process of being archaic, of being slow, of being an expensive process that is entirely out of kilter with modern day requirements. Fair comment, one would say. The current planning system, as I mentioned in the notes, is also blamed for the failure to bring forward residential development sites to enable developers and builders to meet housing demand. Now, I always smile when I look at that, because I look at the amount of construction that I see, residential construction, and for example, where I'm based in the northeast of England, the population is declining, and yet the amount of construction and new build, etc., is extraordinary. And you look at that and say, well, what on earth does that do with regard to the impact on the housing market? Well, yeah, it generates properties for first-time buyers, people coming to the area, etc., etc. But does it not also deflate the housing market? Does it not also lower value? Does it not also impact on the environment, etc.? Well, yeah, of course it does. But the government is interested in making sure that what we've got is a planning regime that is fit for purpose. And one of those purposes is to meet the housing demand that currently exists and demand in the future. There's also a need, it would seem from the white paper, to bring the planning process into the digital age and to allow access to interested parties into the planning process. And of course, that has to be a good thing. So the government white paper deals with lots of different things. First of all, it sort of kickstarts, it reinforces the need to ensure that our housing regime generates affordable housing. One of the linchpins of that is proposed is a fixed rate infrastructure levy. Again, there's detail of this in the notes. Levied on the market value of development upon completion. And the idea is that local authorities have control about the levy and in particular what it's used for. So it could be used to generate discounts for first homes. It could improve services. It could reduce council tax. Interestingly, the white paper doesn't do what a lot of pressure was put on the government for it to do, namely to enable greater investment, broader investment in social housing. National Housing Federation, Institute of Town Planners, lots of other organisations are very supportive of social housing and disappointed that the white paper doesn't deal with it. One of the things that the white paper does promote, however, is that local authorities can borrow against the new infrastructure levy. Again, the idea of kick-starting the process and funding development funding schemes in local areas. No details provided yet as to how that investment is going to be coordinated at a strategic level. Developer contributions could capture land value uplift. Again, I was talking to a chief exec of a housing association, quite a clever guy, well, very clever guy, to be honest with you, just recently, and he was saying that as far as housing is concerned and affordable housing is concerned, his main issue was land values, and that until we could get in a position where we could stabilize land value or reduce land value, any attempt at sort of encouraging first-time buyers, any incentives that can be offered for house purchasers, getting people on the ladder, etc., just distorts the marketplace and just creates additional problems in the market. I suppose he's right, to be honest with you. And therefore, anything that can be done that enables land value to be transmitted into some other format to, I don't know, generate funding for infrastructure or affordable housing has to be a good thing. There is, of course, with regard to all of this, a requirement for resourcing. And again, whilst the government huffs and puffs about lots of different things in the white paper, significantly, it doesn't deal with how the reform of the planning process per se is going to be resourced, other than by saying a fundamental sort of broad statement that as far as funding is concerned, the planning process should be self-funded. So in other words, landowners and developers who generate planning gain should be paying for the planning process. Interesting. I mentioned in the notes that the idea is that there should be a design and placemaking chief officer for every local authority or royal borough. A new post really looking at creating schemes, creating a framework for design consistency in a local area. So, for example, looking at house types, looking at where planning permission can be granted for certain types of extension or alteration, etc. So there's a sort of an idea that as far as the planning process is concerned, let's decentralize it and let's create a sort of framework where developers, builders, homeowners know what they can do with regard to development, and it not being necessary for individual applications to be made for house types, extensions, working in conservation areas, etc., etc. So that's a quite interesting new role, and the reason why that new role is being created is to try and ensure that there's greater emphasis on a sort of a catalogue of house types, catalogue of design ideas, and if we are choosing what we're doing from that catalogue, the planning process should be significantly easier for us. The design and placemaking chief officer and his or her department seems to be key with regard to that concept. The white paper highlights that there should be a refocusing on planning given the fact that we're in the 21st century. So looking at things like decarbonisation, climate resilience, looking at design and beauty, again, this idea of a picture book, a catalogue of things that are permissible in an area, promotion of connectivity and accessibility, promotion of sort of well-being, of environmental issues, but also a need to promote economic growth. Nothing new really in any of that, other than this idea of design and beauty being linked in to this concept of a picture book, a catalogue of choice of design, ideas, etc. The whole idea of that is that where someone is conforming to that design book, that catalogue, the planning process will be significantly easier. I mentioned in the notes in connection with this idea of 21st century issues, this is at page 7 of the notes, one of the things that the white paper does deal with is the idea of speeding up housing delivery for small and medium-sized building firms by the creation of permission in principle, reducing the uncertainty and risk for developers, reducing the idea of the need for land banking, for speculating, for optioning land. Instead, the idea is, as we'll see a little later, land is zoned. We know that if we're buying land within a particular zone, we're going to get planning. And also this idea of design codes, this idea of a national model design code, meaning that in addition to getting permission in principle, we also know precisely what we can and can't do with regard to detail. Quite interesting ideas. Whether or not these ideas ever get into law is interesting. Just to let you know that the white paper is subject to judicial review. where a lot of these issues are going to be discussed and analysed by the court. It'll be interesting to see what the decision will be with regard to that court case. Interestingly, the white paper focuses in on housing, and it's interesting, as I mention in the notes, that there's little mention about how residential development, how housing and infrastructure necessary for it aligns with industrial strategy. And also, I think there's been a missed opportunity at looking at what we do with regard to retail space in the high street. More on that in a moment or two. But again, the white paper is pretty scantily focusing on issues relating to retail and industrial strategies and how that fits with residential and housing development. I mentioned in the notes that one of the things that the white paper doesn't deal with is look at strategic positions relating to housing. So what you've got is very much a sort of micromanagement relating to planning issues relating to housing, rather than looking at the big picture, other than there is within the white paper the need for consideration of schemes between local authorities, sort of inter-local authority strategic schemes, as reference to that. So I do mention on slide here this idea of design codes, and I mention in the notes that in addition to design codes, there is the idea of a future home standard. And the idea of this standard with regard to new builds is that we've got a design that builders and developers know that they can bring forward and utilize in connection with their housing schemes. The idea is that homes built under the new planning system will be fully compliant with energy efficiency issues and other requirements with regard to decarbonisation, etc. I mentioned in the notes item 3, which is at page, where are we? Yeah, page 8. I talk about digital transformation. I'm not going to dwell on this too long, other than to say that planning documentation should be digitalised. I always smile at that and think about the land registry and their huffing and puffing with regard to plans that we're submitting on the basis that they're not correctly scaled, issues with regard to photocopying, scanning, etc. You can see some fun and games, can't you, automatically. Standardisation of processes, all planning documents machine readable, standardised terminology and standardised processes across central and local government, common evidence and analytical capability again. So this standardisation, it sounds marvellous. The immediate thing that comes to mind with me is who's going to pay for all this? You know, if we're looking at costs relating to the idea of design and this idea of a catalogue of design framework, that sounds like an expensive exercise. All of this sounds horrifically expensive. And if we're looking at developers and landowners funding this new planning regime, it immediately says to me, one, fees are going to go up astronomically, which will have an impact on land values, house prices, indeed everything else. And how long is it going to take for this sort of standardization to actually be achieved? Pretty scary stuff, to be honest with you, but there it is. The idea of a digital planning system is there to enable interaction, to enable transparency, to enable neighbourhood and community involvement, it seems to me. So the idea is that just as we can see local plans and development plans, etc., online, we will be able to sort of participate more in planning processes online. And I think one of the things is that involvement, that community involvement, will be in the bigger picture, in strategy, rather than in objecting to planning. So I think what the idea is that they're trying to front load objections and issues with regard to contentious planning permissions. So the idea is that there's community involvement, parish councils, neighbourhoods entitled to participate in the creation of a local plan at a neighbourhood level. Once we've got that front-loaded, all issues, all problems, all disputes, etc., are resolved at that stage. Once that stage is gone through, once the developer wants to commence a planning application with regard to the scheme, there should be little objection, or indeed little opportunity for objection as a consequence. So we're shifting from objection when planning applications are submitted to objection and challenge with regard to the bigger picture relating to local plans. That seems to be the thrust. I mentioned in the notes, as far as data is concerned, there are pilot schemes with some planning authorities using digital engagement tools, allowing public participation. I don't know how successful that's been, but it'd be interesting to see. But clearly the government is hell-bent on pushing that. And I think that the reason is the point I just mentioned. Let's shift objection, challenges, etc., to the front end of the planning process rather than the back end of the process, planning applications per se. There are proposals that I mentioned in the notes at page 9 that the white paper suggests. The idea of development consent orders for exceptionally large schemes and sites. So where we've got new town and we've got developers looking at land assembly and planning challenges, there is a requirement for the use of a development consent order that generates consent for that big scheme. The idea of that is that it is simply there for the large schemes, new towns, big residential or indeed mixed use or commercial schemes or development, not for sort of the little applications for 7, 12 houses or something of that nature. The duty to cooperate applies to local authorities where there's a big strategic scheme that crosses the boundary between one local authority and another. So there are participation in joint planning arrangements to facilitate the bigger scheme. I've given you details. The strong plan-led system that is proposed in the white paper is quite interesting. The idea of this is that there is a simplification of local plans. 3 new development categories: growth areas that are suitable for substantial development, where outlined approval for development is granted as a consequence of land being incorporated into the growth area zone. Renewal zones that are suitable for development, statutory presumption in favour of development being granted for specific use. And then finally, protected zones, where there are more stringent development controls, but significantly, these are protected zones. They are not, like Greenbelt is at the moment, sort of cast in stone as being zones or areas where development will not be possible. Of course, there has been a relaxation of the rules relating to the Greenbelt. Some environmentalists had hoped that the white paper would sort of reinstate that old regime with regard to ensuring Greenbelt is preserved. A protected zone, I don't think, affords that accommodation. As far as local plans are concerned and bringing forward local plans are concerned, the white paper proposals is simply this, that local authorities have a duty to adopt a new local plan by a specified date, which is either 30 months from legislation being brought into force or 42 months for local planning authorities who have adopted a local plan within the previous 3 years. Again, the idea of this is let's create a regime that means this local plan doesn't just sit in the ether and actually is brought forward relatively quickly in planning terms, enabling land to be released for development. Again, emphasis on design principles with the use of national and local design guides and codes. Now, this will be significant for us that are participating in the conveyancing process. I'll explain why a little later. But the idea of this design guide, this code, this catalogue with regard to what can be permitted and what won't be, I think, is the main thrust of what this white paper is attempting to do. There is no evidence within the white paper how all of this is going to speed up the planning process, how it's going to provide flexibility, but it's implicit, isn't it, in what's being suggested, that if we are going to adopt or stick with the design brief or the design guide, we're going to get a smoother planning process and a more streamlined process. As far as changes to local plans are concerned, the idea is that this should halve the time to enable a landowner or developer to bring land forward to enable houses to be built or development to take place. The aim is that the time for that process should be reduced by 50%. And a front loading, as I've mentioned before, of the deliberation process, which slows down the planning process at the back end, as I mentioned. Now, I talked in the past and just recently about neighbourhood planning. Important if we're acting for a client who is intent on undertaking some form of development with regard to a property that's being purchased, or we're acting for small-scale developers, in addition to talking to local planners, town planners at local authorities or within local boroughs, the idea of neighbourhood planning, I think, creates another task for clients or developers that are intent on undertaking development work. Namely, that the idea of a neighbourhood plan created by a parish council or neighbourhood forum generates another hurdle for our client. The significance of this is, rather than parish councils, neighbourhood forums, neighbours generally intervening in objecting to planning applications, the promotion of neighbourhood planning means that they actually participate in the creation of the local plan. So where a planning application is submitted, the local authority has to take into account any neighbourhood plan that has been proposed. So again, this means that we've got another layer of activity in connection with the creation of the local plan, consideration of what neighbourhoods and neighbourhood planning involves. That then has to be taken forward into the local plan. But once that's done, assuming that a development is within the confines of a neighbourhood plan and is within the confines of the 3-zone system that the local plan adopts, then we've got a situation that our planning application should be unchallenged, subject to what I'm going to say in a little while. So the idea of neighbourhood planning is quite interesting. It's optional, but I think the thrust of what the government is saying is that the idea of neighbourhood planning should be adopted by local authorities. Neighbourhood planning, nothing new, by the way, created courtesy of the Localism Act 2011, but greater emphasis placed on it with regard to the government white paper. So we've got neighbourhood development plans, neighbourhood development orders, community rights to build orders. Important as part of the planning process, as important as part of sort of preliminary activity that a client might undertake with regard to what he or she intends to do with regard to a residential property that's being acquired. We need to look at development plans, development orders to see what parish councils, see what local neighbourhood organisations or neighbourhood forums, as the white paper suggests, have to say about what we're doing. So we're going to have to look at design codes, design guides, the catalogue. We're going to have to look at what neighbourhood planning has generated with regard to our site, and then we've got to look at the local plan as well. So there's a lot more front-end work, and again, it harks back to that point that I made in my introduction, just what is our role? Are we undertaking or assisting our client with finding out the opportunity for planning or development with regard to the property that we're acquiring, or are we simply advising the client as to the current planning status of the property that's being acquired? There is something new that I mentioned in the notes, community rights to build orders. And the idea here is to promote, ideally, sort of starter homes, new builds, etc., that are going to enable neighbourhood residential development. Small scale development that is sort of neighbourhood driven. So community groups can grant permissions for new buildings that they want to see go ahead. Again, this idea of interactivity and this, again, idea of micromanagement. There's been a lot of criticisms with regard to what the government is referring to. First of all, where on earth are we going to get the resources for all of this? Two, it's probably too much all at once. It's a radical and wholesale reform of the process. More on that when we talk about what a residential conveyancer needs to do. It removes flexibility, says a number of organisations. I've given you some detail in the notes there. It doesn't deal sufficiently with infrastructure. There's not a lot of joined up thinking with regard to it. And that makes sense, doesn't it? If we're not looking at the bigger picture, but we're looking at neighbourhoods, then infrastructure and issues associated with it to an extent are lost. All these comments that I've given you within the notes were highlighted in a report that was in the Estates Gazette just recently. So I've just extracted what a lot of people have said about what they think will happen. It's a sort of quite a broad church as to views and positions. Again, it doesn't deal with energy efficiency adequately, doesn't deal with land banking problems. Again, when I first started off in practice, one of the things that I used to spend a lot of time doing for residential developers was land banking. We'd have short-term, medium and long-term strategic land banking. These days, you don't see as much of that. I think, again, the idea of the white paper is to try and generate immediate land that's suitable for housing, and not a great deal of thought is being given with regard to the future in that regard. So whilst you can criticise it for not dealing with land banking, you can argue that bringing forward sites for residential development now perhaps is far better. So that's the reform. Let's have a look at what we've actually got now with regard to some practice points. So this is at page 15 of the notes. First point, fundamental point for residential conveyancers and indeed commercial property lawyers. Any reform of planning law, whether we're firming up the law to protect the environment or we're relaxing it to allow more housing, is going to create problems for conveyancers. Why? We don't know what the future holds. We don't know how much of this is going to come into law and what the impact will be in connection with the housing market generally. So we've got a client who's buying a rural property at the moment. He's very impressed with the views he's got, the open aspect of the site, the fact that it's a lovely village and there's no development intended. Local plan reveals that there's nothing envisaged. We've got green belt all around us, etc. Happy days. The client needs to be aware of the fact that we've got here an opportunity for some radical reform of planning generally that could impact on that village and our client's choice of property. Nothing we can do about it. We can't say to the client, hey, you should buy or you shouldn't buy. I think we've just got to warn. Second point, when acting for a buyer, we've got to identify a client objective, and we've got to limit the scope of our retainer and explain to the client that our role is to identify current planning status of target property and to make sure that the status of the property matches the client's objective. If a client is thinking about development as well as talking to planners, it may be necessary, if neighbourhood forums, etc., take off and are created in the area, but it's necessary to consult with them. And of course, the need to recommend specialist planning advice too. If and when we see these design guides, etc., this design framework, again, we've got to refer that to our client too. If we're acting for sellers of land, of plots, we do need to consider the imposition of enforceable restrictive covenants to prevent planning gain. In the good old days, you could have a look at a site and say, well, yeah, all right, there's a bit of garden there that might get some form of residential development, but all it's going to be is the development of one unit, and it's going to be a bungalow because everything else in the vicinity is a bungalow as well. I don't think we can be quite as secure in connection with our thoughts now as we were in the future. With planning regimes in a state of flux, sites that have no planning potential at all today could have the opportunity for a planning windfall tomorrow. We've got to, I think, whenever we're selling bare land, wherever we're selling land with potential for development, explain to our client that they may unfortunately find out at a later date that someone has generated a significant advantage as a consequence of some form of planning gain. And I think we've got to take a robust approach to searches, making sure clients understand the limitations relating to searches that are undertaken. And again, I hark back to that point that I made at the start of my presentation. So, permitted development rights and residential conveyancing, this is law. And what we've got is some town and country permitted development regulations which came into force on the 1st of August. And they generate a number of things that I think are quite interesting. Firstly, the availability of permitted development by the creation of additional stories. And the idea here is that what we're doing is allowing vertical extension to generate an opportunity for development that means new housing can be efficiently obtained without severe environmental impact and without land use. So it's intensification, isn't it? So the idea here is that we've got an opportunity for developers to extend blocks of property. We've got an opportunity for homeowners to extend upwards to generate additional space for families. The idea here is that the development rights are going to lead to a wider range of development and they're going to speed up the delivery of housing. Well, it makes sense, doesn't it? So what we've got is, first of all, a fact that these use classes, again, are subject to judicial review. And again, we're waiting to see what's going to happen relating to that court case, which is going to be heard very shortly from what I can gather. We've got a new Class A into the General Development Purposes Order, new developments on detached blocks of flats, the right to extend purpose-built blocks of flats upwards by 2 additional stories. Note, the block of flats has to be 3 stories to start with, and we can't extend above 30 meters. And as far as that is concerned, therefore, it is important to understand that where we're acting for people that are buying flats, this new permitted development right means that developers, owners of blocks of flats, reversioners are going to have an easier run from a planning perspective with regard to building up and with regard to development. Clients who are buying flats in blocks of flats need to be aware of that. I mentioned in the notes that there is, in addition to this, a permitted development right with regard to additional stories on business premises and single dwelling houses. Again, important that clients are aware of this. Clients are made aware of the opportunity this generates, but also the impact that this could have with regard to a property that they acquire. Again, the position is that if I'm instructing you to act for me in connection with the purchase of a flat, absolutely essential that we look at our lease to see what development rights are retained by the builder or developer. Very important to ascertain the position with regard to the extent of the demise when we're buying a top floor flat or apartment, and that we check to ensure whether or not a builder or developer has retained airspace, retained ownership of the roof and roof void, all of which are going to be necessary, of course, if a developer or landowner or reversioner is going to take up the opportunity that permitted development rights generates. Just going on a little further, it is important to understand that the rights are subject to prior approval from the local planning authority. they do require an application to be made, and the local authority can consider all the usual raft of planning issues with regard to whether or not permission is granted or not. There is an obligation to consult, and there are limitations. As far as some of those conditions and limitations are concerned, I've given you details. In particular, the rights only apply to buildings constructed between the 1st of July 1948 and the 5th of March 2018. So, in addition to that, I mentioned the white paper proposal again recommends the creation of additional permitted development rights for popular and replicable forms of development. The idea here is, again, the creation of pattern books in connection with building types, extensions, etc., meaning that planning permission could be granted by a local development order or our old friend, the Neighbourhood Development Order. So here again, you've got this idea of a catalogue. I want to build an extension, I want to build a house. What I'm proposing is laid out within that catalogue and then given a very smooth run with regard to a planning application. So, practice points, page 19. Good idea to warn clients who are buying flats about change of regime and greater risk of development. Should be doing that in any event. We should be looking at our leases to see how quiet enjoyment, non-derogation from grant provision within the lease could potentially afford protection for our client, and to see issues with regard to airspace, void, roof are dealt with within the lease. It might be prudent to highlight to clients where a landlord or developer has retained or reserved development rights and the building is being built within the time frame that we just mentioned, that the opportunity to challenge what the builder or developer is proposing within the planning regime will be limited. If acting for a sale of a property which has the potential for upward development, again, think about the imposition of a restrictive covenant or the retention of airspace to try and ensure that if there is planning gain, our client derives some benefit from that gain. If design codes are introduced and the client intends to undertake development, important that our client is aware of those codes, and equally if our client is intent on challenging planning permissions, that again the design codes are considered and the client is made aware of them. Remember, where our client is intent on undertaking any form of development as a transactional property lawyer, we should limit the scope of our retainer. In the notes, I was thinking about all of this with regard to building upwards, etc., and saying, well, all right, yeah, fair enough, I get that with regard to intensification, I get that with regard to better land use, etc. But then the skeptic in me said, hang on a minute, might there not be something in this that extracts the government from the problem that they've got with regard to cladding? If we're going to allow additional development with regard to blocks of flats, etc., might a levy be introduced in connection with upward development that can be utilised to defray the costs that there's no doubt in my mind ultimately going to fall at the feet of government with regard to decladding and recladding? But that perhaps is just me. Covered lots of things today. It's really interesting, to be honest with you. There's no doubt in my mind that we're going to see this become law. And there's no doubt in my mind that what we're going to see are some radical changes that are going to impact on the entire planning process. And it's also fairly clear, as it has been in the past, that where there are radical changes with regard to planning, buyers and sellers can catch a cold, encounter problems, and if we have acted for a client in a transaction where the client has sustained loss or problems have been generated as a consequence of planning issues, then surprise, surprise, they may well look to us to see if we've been negligent with regard to the work that we've done. To avoid that, do the simple things well. Identify client objective, identify our role, and if clients need guidance, make sure that we either provide that guidance or we point the client in the direction of that guidance. I mentioned at the start, if anyone had any questions, that we're happy to deal with them. Stephen, if you're around, that would be great. But if not, then there's an email address for myself. Robert, I haven't sort of introduced you today, which is very remiss of me, so I apologize for that. Any comments, any points to note with regard to product, or any ideas, having looked at the law in this area, about what you think relating to the government's stance and the government's rationale behind the white paper?
Yeah, well, as you know, Ian, I'm a great fan of the old planning procedure because I think it's a great democratic power. And despite what the industry says, I think it's in average year 88% of all applications get passed. So it may be a reform for ideological reasons rather than practical ones. However, that doesn't stop us as insurers trying to make money out of it. And I'm fairly certain that as homeowners lose the right to object or to challenge their neighbours on planning, areas like restrictive covenants and rights like that will come into play. And again, it's something to be alert to as a lawyer, that your client may have ways to limit or restrict development, or even to share in the value of it by using restrictive covenants in that way. So I think we'll probably see more of those sorts of disputes, which in turn means if you're advising somebody buying a house subject to restrictive covenants, look at an insurance policy now, because it may well be protecting your ability to develop in the future.
Yeah, that's a good point. Really good point. Yeah. It's interesting, isn't it? That as a transactional property lawyer, what do I do with regard to planning? And do you agree that I think as I mentioned in my presentation there, that there is this mist, isn't there, with regard to clients, or a fog in some client circumstances, where they don't really understand what we're doing, and we, as a transactional property lawyer, don't understand that the client doesn't understand. And that's where problems and issues can arise, which is why I say we've got to be quite specific about drawing the line as to what we're doing and what we're not doing.
Yeah, I think you're right there, Ian. I think the problem is probably that as conveyancers, we see a property purchase as a time limited item. We do it, they buy the house, they move on. Homeowners do see it as a long-term thing, and if in 2 years' time they think, actually, I would like to build 2 more stories, they will think, why didn't that idiot tell me about it 2 years ago? And is that what you're saying there? To limit your instruction, to clearly define your instructions to what is required at the time is essential. Otherwise, clients will, rightly or wrongly, wonder why you didn't explain something that they need in the future.
Yeah, Robert, I've just thought there is a bit of good news about all of this, given the fact that I'm a great believer in communicating with, just as you were saying there about our relationship with clients. Once the file is closed, we go off and get on with the next transaction. Client goes off skipping into the sunset. Where there is reform of the law, it's a great opportunity to communicate with old clients to say, hey, look, have you seen this? And when we talk about creating goodwill, etc., I always say an e-shot or an email to clients, or a little sort of newsletter to clients. Hey, look, have you seen this reform of the law, or these suggestions? Can often sort of generate rewards with regard to new instructions. I often say to firms, any opportunity you can have to communicate with a client that you haven't heard of in the last year is a great opportunity, because it's amazing. That communication with a client brings you back into their sort of memory bank, and you never know if they are moving or they've got a friend or family that's moving, you might just get a referral. So always bear in mind the fact that, this is a pain, it's got us rethinking about our systems and processes, etc. But it also is an opportunity to educate, or to try and educate our clients relating to reform, in the hope that they remember us and perhaps instruct us with regard to a new matter. Any other comment, Robert?
No, I mean, the other one, which is a practical one for insurers, is as people will know, when getting or applying for title insurance, quite often insurers want to know about the planning history and about any objections. So as we broaden the permitted development rights, that removes that first public examination of it. So it again throws it up more, certainly unknown what your neighbours may do if they haven't had the chance to object already. So it's an area which the insurance industry needs to think about when underwriting these risks in the future. And just something to be borne in mind now, because that initial hit for a neighbour to complain has gone now in some cases.
Yeah, it's interesting. There was another article in the States Gazette about judicial review, you know, and the government's thinking with regard to all of this is if we create these new systems and processes, it means that we're going to stop applicants applying for judicial review. There's an interesting article in the States Gazette saying, no, that's not going to happen. You know, aggrieved neighbours are going to do everything within their power to stop development. And no matter what the process, there will be some potential for procedural irregularity that means judicial review is going to be just as active a means of sort of seeking redress or a means of preventing development as it always has been. Very interesting article, to be honest with you. And certainly I know that the government did think that this reform would lead to less, as I mentioned, back-end challenge. But certainly they're not going to be able to prevent or preclude judicial review applications. And of course, as far as judicial review is concerned, you know, relatively easy process, assuming objectors have funding to scupper or stall development plans. Good. Stephen, do we have any questions?
Thanks, Ian. Yeah, there are a couple of questions. What I will do, though, just as a reminder to everyone, if you want to submit a question to Ian, you can so by the questions tab. Just giving you a second if anyone does want to submit anything. We have got a few to get through. I'll just run a quick poll in the meantime, just for 30 seconds or so. So it's with reference to the current work levels. So do you expect the current levels of work to continue until the end of the month, the end of the furlough scheme, continue to Christmas, or continue until March 2021? Hopefully you are all still busy currently, that's of course, but I think as a market we've definitely seen transactions increase over the summer, which has been great. I'll just leave that poll open for another second. Ian, while that poll is running, I'll get onto the questions, that's okay. So we've had a question from Corin, and Corin asks, how does the idea of a design officer fit in with the design guides in a neighbourhood plan? Which would be more important? Will the new officer and his design have to take into account the neighbourhood plan design guide?
Yeah, it does. I think the idea of this design officer is that he oversees the catalogue. Yeah, and I think as far as neighbourhood planning is concerned, there is input into the catalogue that is created. So I think what you're going to get is central government saying, right, this is the sort of house types we want, this is the sort of scheme or development that we want generally, but then what you're going to see is a trickle-down effect into local authorities who then can put their own slant on it, and I think they've got to be fed by this neighbourhood planning scheme to sort of contribute. So you're not gonna have a design book or a design code imposed on you. There will be the concept, but then there'll be sort of local participation and a local finalisation of what would be appropriate for that area. So I think that's how it would work, Stephen.
Yeah, no, perfect. Thank you. Thanks, Ian, and thanks, Corin, for the question. I say follow up to that. It's not quite in the same area, of course, but Corin also asks, our local district authority state that the local plan takes precedence. The neighbourhood was passed by the examiner and before the local plan was passed. Are you able to state the statutory provision that says that the NP takes precedence, which is the neighbourhood?
On that precedent, if you ask Corin to drop me a note by email, Stephen, I'll go scurrying off to find the law relating to that. I don't have it to hand, unfortunately, but I'm happy to do scurrying and find out.
Certainly, we can do that. Thank you. And then last question we have is one from Robert McNally. He says, with regard to the new build-up brackets above existing residential blocks, is there anything to indicate that the government is also looking at amending the law relating to rights of light, as otherwise the existence of rights of light will act as a significant barrier to this exercise of new statutory right to create additional residential accommodation?
Great question, Robert. The Law Commission has looked at rights to light and identified the law needs reform, but there's nothing planned at the moment from the government to tighten or slacken the law relating to rights to light. But certainly it is an area that will require reform or will require addressing, given what the government's proposing. Great question.
Absolutely, yes. And I think it's been quiet for a number of years on the Law Commission paper on rights of light. So it'd be interesting to see if that's brought up again in the coming years. Ian, you may have seen that the poll has closed there. So
yes.
The majority of people saying that they expect the market to continue to March 2021. Obviously, that being a significant date because of the stamp duty holiday. Yeah. Will be interesting to see, of course, what happens after that, whether the government looks for other ways to try and keep the residential market stimulated. But I don't think too surprised about those results that we're seeing. But what are your thoughts here?
No, it is interesting. I mean, there's no doubt at all in my mind that the SDLT holiday has certainly generated interest, generated business, and it's been good, been very good for the residential conveyancing market. I still maintain that there was business that should have been done, transactions that should have been completed in lockdown, and we're probably still seeing some of that as well. So it's not all SDLT related. And in addition to that, there's always a base level of conveyancing, isn't there? You know, no matter how bad the market is, and people have said to me over the years, conveyancing, the resi market runs in 5-year cycles. And even at the bottom of that cycle, even when we're at its worst, there's always a base level of conveyancing. And I think there is. So really what I think is we've got still an element of sort of lockdown activity. We've got, in addition to that, the huge amount of interest that the SDLT holidays created, and we've also got a base level too. I mean, someone was saying to me that they had a property for sale in Devon, and they were just astounded as the amount of interest. People that in the past were commuting into London that were now thinking, well, I don't have to commute into London anymore, so I'll buy this rural property in Devon. So, you know, I think there must be a bit of that as well. I don't know what you think, Stephen. So, you know, there's lots of things that, you know, stimulating demand for conveyancing, which is great news. But it has to come to an end at some point. And, you know, to say, well, you know, is the government going to try and do something else to stimulate the market? Well, they should do, but the issue there is, can they afford to do it? I don't know what you think, Stephen or Robert, but that's sort of my take on the current position. But as I say, we're really crystal ball game as to what happens in the future.
No, I agree. I do agree with that, Ian. I think, and I do think there will, as it stands, there will be a drop off in April. There's bound to be, but I do suspect the government will try and put something else in place to incentivise people to move. And obviously, as you say, there are still so many mitigating circumstances and reasons for people to consider future moves. So and of course the final point you made as well.
Yeah, Stephen, I'll tell you what I think is really interesting, that normally you can track conveyancing business and it's seasonal. So, you know, August, you do nothing. Christmas time, there's a run up to Christmas, then you get to January and it dies. And again, I don't know what you think, you and Robert think, from your perspective. From my perspective, in the past, no one would ever want training in August. No one would ever want training in December. I was really busy training in August. My diary is really busy for December this year. So I think that we're not going to see the same sort of peaks and troughs with regard to conveyancing that is seasonal, given the points that we've just sort of discussed a little earlier. So that's quite interesting. Did you notice that? I think you and Robert were telling me that you were busy in August.
Oh, absolutely, yeah. But you know, and I think for ourselves and anyone, because it's the time of year for trying to forecast and plan into 2021. Good luck with that, because it's just, as you say, so in the air, and even the seasonality is going from that.
Yeah.
I've deliberated whether to mention this comment, but it did amuse me. Mark Cairns has commented, "We're seeing similar up here on the edge of the Peak District. Softy Southerners snapping up what would be holiday lets." So slightly controversial view there, but I think that's correct. I think as the dynamic changes from working in the office, there definitely is that sort of thing happening. And why not move to the Lake District? It's superb up there.
I like that.
Anyway, indeed, yeah. Anyway, I will leave it there. I appreciate we're well over the hour. Thank you to everyone for attending today and for staying on to the end there. Thank you to Ian and to Robert for his comments as well. If you have any other questions, please do get in touch. You will receive a automated email after today's session from GoToWebinar. If you respond to this, I receive that directly, so I can pass on any feedback or questions to Ian or Robert, or try and answer anything you may have questions about myself. You will also receive a separate email from Robert in the next 24 to 48 hours, which will contain the slides for today's session, a recording of the session, and the notes as well for anyone that hasn't been able to obtain those today. So on behalf of Stewart Title, Ian, Robert, and myself, thank you for joining us today, and have a great rest of your day. Thanks everyone. Goodbye.
Thank you, Stephen. Thanks, everybody.